delivering added value to business. And during the pandemic and understanding the challenge of new normal, we believe as the regional alliance, it is our job to support in-house community across the region to understand the impact to regulation and business. What is the challenges and how in-house should anticipate advising business. I also want to use this opportunity to convey that we are so keen to later someday see Bangladesh become our member, a member of APCA. So if there is any in-house counsel right now already existed in Bangladesh, please reach out to us and discuss how we can build the partnership between APCA and your association. If not yet, I'm encouraging participants in the call to explore the establishment of the country in Bangladesh, the country association in Bangladesh. I was the president of ICCA Indonesia, and Anil was also the member board of Singapore Association. Our learning show us that by having association may help a lot for networking and knowledge sharing, especially as a country with promising economic growth and looking at the numbers of lawyers and in-house in Bangladesh. I personally believe it's about time for Bangladesh to have its own association. As APCA has been set for the regions for quite a while, we are ready to facilitate any association of in-house, including in Bangladesh later, to connect and work together any initiative that could give benefit for all members across the region. Lastly, I would like to say thank you to our member, Singapore Corporate Counsel Association, for supporting this event by providing its digital platform, making this webinar to be happen. That's all from me. Hope you enjoy this webinar. Have a pleasant webinar and hope it will be a lot of benefit that you will learn today. I hand it over back again the screen and the mic to the moderator, Anil.
Yeah, thank you very much. So for the first speaker, is Dr. Khaled Chowdhury. Honestly speaking, those of you from Bangladesh need no introduction to this fine gentleman. An incredible gentleman who has for many years acted as a practiced law and has also taught a lot of the young lawyers. The amount of young lawyers that I met in December last year who knows Dr. Chowdhury and his teaching abilities are incredible. But you know, along with that comes a whole lot of. He's an absolutely talented gentleman. You know, he's got a band and he sings and a lot of other things that he does. But today he is going to come speak to us from a perspective of a little bit about the regulatory framework and how you know, it may or may not affect the in-house lawyers. Over to you, Dr. Chowdhury.
Thank you very much. The audience and of course the Asia-Pacific Corporate Counsel Alliance, APCCA and ACCA, and Anil in particular and the team for giving me the floor and for the invitation, kind invitation. We know time is of the essence and the times are very challenging. So without much further ado, I'd like to start with my presentation on understanding the Bangladesh regulatory and business framework arising from COVID-19. Firstly, as an introduction, I would say that the legal system of Bangladesh, based on its common law tradition or heritage from the British domain, has seen little changes to its core laws since its independence in 1971. Hence, the time-tested codes of civil and criminal procedure, penal code, evidence, laws of contracts, specific relief, limitations still forms foundations of the core legal practice. In addition, Islamic laws have its influence in family law and in some cases penal law, and to some extent in financial laws. Laws relating to business have developed mostly in a piecemeal fashion. Now, a bit about the in-house lawyering, since it's an association of corporate lawyers, I think it would be helpful. Now, unlike UK and many other or a number of other common law jurisdictions, the legal profession in Bangladesh is not split. Okay. Hence, in order to practice in the courts, one has to qualify as an advocate, whereas a call to the bar from England and Wales would definitely give a person a practical head start in a number of scenarios. Now, despite having some negative connotation in the past, being an in-house counsel is now perceived to be a demanding and challenging one to the profession in Bangladesh. This has been compounded by the fact that we have had just three bar council examinations, enrollment exams the last 6 years, And in the last time, we had 42,000 graduates sitting the exams with just over 20% pass rate. Hence, many UK and foreign qualified lawyers without a right of audience compete for places in top corporate legal departments, focusing on variety of works. One would be surprised to know that for nearly 170 million people, we have only roughly about 50,000 or so lawyers and just over 1,800 judges. Now, be that as it may, in-house lawyers are now dominating the legal departments in many leading multinational enterprises, banks, telecom providers, and so forth. Now, the Bar Council so far has not seen this in any negative light. Perhaps I would say it's an implied acknowledgement of the demands of the situation. Now, about the business and regulatory framework, as I've said, that our highest law, the Constitution of Bangladesh, enshrines rights to enjoyment of equal protection of the law and to be treated in accordance with law, and in particular, actions detrimental to life, liberty, body, reputation, property of any person to be taken, not to be taken except in accordance with law. Now, there are rights of lawful profession, occupation, and business, and also right to acquire property. Now, Article 44 provides our citizens the avenue for the enforcement of the fundamental rights before the High Court Division of the Supreme Court of Bangladesh by filing an application for judicial review, which is its jurisdiction under Article 102. So any act passed by the legislature violating fundamental rights may be declared unconstitutional, and any executive decisions may be challenged by way of writs of mandamus, certiorari, prohibition, etc. This definitely has given redress to the business community on a number of occasions against encroachment of property, licensing, imposition of taxes and duties where there were no efficacious alternative remedies. Now, the basic laws related to contracts, companies, partnerships, sales, agencies, insurance, banking and non-banking financial institutions, recovery of money loan, insolvency, bankruptcy, etc., are all there to deal with the respective dispute resolution issues. There is a dedicated public procurement regime by way of the relevant act and rules where e-tendering is allowed following international norms and standards. Competition Act 2012 was enacted to promote and maintain market competition by regulating anti-competitive behavior and arrangements amongst the companies. Bangladesh Bank, our central bank, has a supervisory role on a number of issues, including monetary and credit policies, regulation of banks and non-banking financial institutions, development of domestic financial markets, payment system to prevent money laundering, implementation of foreign exchange regulation, etc. The much talked about issues of money laundering, which is linked to proper and fair banking sector or financial sector governance, are investigated by the relevant Financial Intelligence Unit pursuant to the Act, the Money Laundering Prevention Act 2012. Now, the two stock exchanges in Dhaka and Chittagong are overseen under the auspices of the central bank by the Securities and Exchange Commission, formed in 1993. There is Anti-Corruption Commission, ACC, and an independent commission formed in 2003 to look into matters involving white-collar crimes of corporate fraud, including bribery, embezzlement, extortion, and abuse of discretion, etc. There is an updated Arbitration Act 2001 based on ancestral model law to make ADR faster. Bangladesh Labour Act 2006 is a comprehensive code or act aimed at ensuring that rights of workers are protected. The rights of the consumers have been further entrenched by Consumer Right Protections Act 2009. E-commerce has picked up, with the government making efforts to make the country digital by 2021. Steps have been taken to boost up the IT industry by waiver of taxes, declaring tax holidays, etc. Intellectual property rights are protected by relevant laws, including the Copyright Act and the Trademarks Act and other rules. All types of businesses in Bangladesh are allowed, subject to exceptions, permissions being granted. Rapid economic growth, pre-pandemic, of course, enabled Bangladesh to become a lower middle income country in 2015, fulfilling the World Bank's requirements like GNI per capita on that basis. And in 2018, United Nations recognized Bangladesh to be a developing country. Deregulation, privatization, and I would say adequate legal protection have encouraged foreign direct investment in Bangladesh. Now, this is further encouraged, of course, subject to approvals that include 100% foreign ownership and repatriation of invested capital, profit and dividends, and there are various incentives for 100% export-oriented industries, as in no import duty on raw materials, to say one few. Duty-free import of capital, machinery, and spares, etc., are also encouraged and allowed. In 2019, our foreign direct investment hit an all-time high of US dollar 3.68 billion. Now, impact of COVID-19. Now, Bangladesh being the 8th most populous country, ranking 10th in density, obviously the impact of COVID-19 has been disastrous. We have a slum population which is rising, have 1 million Rohingya refugees to look at. We are yet to reach the peak, and current figure stands at over 100,000 people affected by the virus, with death toll approaching 1,400 by the official figures. Our healthcare system has been stretched to its limit. Economy was shut since the middle of March, now with limited opening currently, I would say, with lives being at risk. The pandemic is said to wipe out over $3 billion from our economy. It may lead 1 million people being unemployed, and growth of property may rise alarmingly. And the latest data shows that private sector growth has declined to 8% in this quarter, and the foreign direct investment has seen only an increase of 4%. The government of Bangladesh has provided stimulus package worth $10 billion for many export-oriented sectors, but the banks, but the banking sector itself is already under a lot of challenge due to high non-performing loans, low profitability, and sometimes weak management. Now, there are concerns that new loan opportunities might create additional burden on the banking sector. Now, we can see that it might be quite difficult for us to reach an economic growth as forecasted of 8%, with World Bank forecasting only 2 to 3% this year and IMF only 2%. Now, over 10 million migrants from Bangladesh sent over US dollar 18 billion to the country in 2019, and World Bank and Bangladesh Bank estimates suggests a gloomy fall of this figure by 25% due to the current pandemic. Obviously, unemployment is on the rise in those countries of their employment. In the labor sector, the stimulus has helped the industry to keep moving instead of laying off workers, which would have led to countless disputes of employment, as there were some gaps in the law. Due to that reason, factories would have to shut down, not by the employers, but due to the lockdown orders from the state. Bangladesh garments industry, that accounts for almost 80% plus of its country's exports revenue, have faced disastrous consequences since the hit of the pandemic. At least 1 million workers were fired or furloughed by April, about a quarter of the industry's Bangladeshi workforce. Moreover, now they have to deal with initially cancelled orders, where buyers are now seeking a comeback with heavily discounted fresh offers. Allegedly, some orders were cancelled for products shipped more than 3 months ago. This one report says costs payment of over US dollar 3 billion for products already made, and the cumulative liability for unfinished product would reach almost 10 billion. They mostly pleaded force majeure, and our industry, often lacking the ability to bargain, had to give up to many of those unfair demands. The issue of force majeure is thus largely accepted unchallenged. Now, in the recent years, many buyers also took advantage of, I would say, inequality of bargaining powers, also making suppliers agree on the basis of purchase orders without resorting to the conventional payment by letters of credit, or without even offering a standard sales contract, leaving suppliers without much legal safeguards. As a consequence, today, supplying countries are facing order cancellations, pressure to issue payment discounts, suspensions, and other alterations with no legal avenue to fight back. There are further complications created by deferred payment mechanisms. At any rate, a comprehensive act such as one passed in Singapore would have allayed doubts about COVID-19 being a force majeure event. It might have given parties the relief from performance of contracts, made renegotiation easier, fairer, and taken care of limitation periods prescribed under the general and special laws. As has been said, the pandemic froze avenues of access to justice as the system did not yet evolve on e-platform in March. However, after some initial hesitance, as the virus started to spread, the need was truly felt, and as a result, an ordinance has been passed last month, followed by a number of practice directions allowing courts to perform and function virtually. A comprehensive, digitalized, dedicated e-judicial system is yet to develop. As of now, mostly urgent matters are being heard. The lower tier is also coping up gradually with the e-learning platform. There are many challenges ensuring proper and dedicated platform. Hence, training, fully fledged logistics is the call of the time. Now, even before pandemic, our judicial system had been clogged with over 4 million cases with ADR not making the inroads as desired due to a variety of obstacles. In a study, Doing Business 2020, the World Bank Forum in Bangladesh has moved up to 8 places to 168 out of 190 economies. And this covered areas such as starting a business, getting necessary permissions, registrations and credits, taxations, trading across borders, and here most significantly, enforcement of contracts, which is closely knit with efficiency, speed of dispute resolution methods. Here we've been placed at 189. Hence, from filing a case to enforcement of judgment, an average of 1442 days has to be spent has been shown, and the cost of the claim value stands at 66%. Obviously, there is a considerable need for improvement. Hence, what we see, ironically, I would say, on a positive note, COVID-19 may be seen as a blessing in disguise, inasmuch as online dispute resolution is picking up, which would lead to quicker and perhaps more efficient way of resolution of dispute. The final few points, there is a lack of structured, well-reasoned negotiation culture to resolve disputes. Arbitration is somewhat a bit expensive, and there is an obstacle to enforce international arbitration awards when the district courts are seized with the matter. For this, much of the anticipated benefit that would have followed from the application of New York Convention is lost. Now, our Civil Procedure Code has been amended to encourage mediation, but that is yet to be made mandatory in civil suits. It was made mandatory, but yet not in force, and we are yet to be a party to the Singapore Convention 2019, which I hope we should soon be joining. ADR provisions nevertheless feature under a number of statutes, including labor, money loan recovery, VAT, customs, and income tax. NGOs, our legal aid officers, and community people are also working progressively despite challenges to resolve small claim dispute via ADR mechanism. In the end, we need to fight our way back during and post-pandemic with the rest of the world. Mankind must prevail.